I applied for the Georgia Supreme Court, my dad, who's my harshest critic, who's been a member of the bar since 1950, said, "Are you sure you have the intellect to be an appellate judge?" Anyway, obviously the governor didn't think so. Congratulations to Justice Thomas.
And what we're having to do now within the Caperton decision is move on to step two, beyond White, and say, okay, we're going to have popular elected judges. We're going to allow a free flow of information under the First Amendment. But, that being said, what happens when particular litigants participate in a campaign and then appear immediately after that campaign before that judge? And therein lies the question that we're going to have to be debating here. And I think, quite frankly, this is one of the rare situations where both sides of the issue in the court got it right. The majority clearly understood that what took place in that case had clearly crossed the line, and they said that there should be an objective standard out there, meaning how a reasonable judge could be influenced by particular activities. But at the same time, the dissent also said, no, wait a minute, you're enacting a standard without any real guidelines. And you are, in effect, opening up a Pandora's box without any clear path on how to get out of the quagmire that you put us into. What I found most interesting was that both the majority and the minority decisions clearly stated that the states should fill that void, and called upon the states to fill that void. And that's going to be the challenge that we have as we approach next legislative session, or for that matter, if the judges themselves should come forward with some standards on their own.
There are questions raised in Caperton, and I think Justice Roberts has it right to raise some of these questions. If you're going to say that, well, first of all, one important fact about this case. The judge received from Massey a $1,000 contribution. All the remaining money that's in question went to an independent third party and independent expenditure. And I think that's a real important decision. For that to be a legal act, there has to be no coordination between the candidate, the presumed beneficiary of it, and those that are contributing that money. And that's an important distinction. To hold the judge accountable for the independent actions of another, when he may, in fact, as Justice Roberts pointed out, might not have even welcomed that expenditure, is somewhat suspect in my mind. And the other issues of recusal, I mean, there's so many. I don't know that this outweighs geography. If you're ruling in the case that benefits a particular area of the country you're from, you have friendships and associations with groups and individuals on all sides. So I don't think the court really left us much specific guidance in terms of where a judge should recuse himself. That may be best left, as is the case in some of the decisions yesterday, where some of our Georgia Supreme Court justices recused themselves from certain cases.